Let's consider the issues today. Our first panel is consists of members of Congress. First panelist is a gentlelady from the 39th District of California, Representative Linda Sanchez. She is in her fourth term and is a member of the Judiciary Committee and the Ways and Means Committee, and she is the primary author of H.R. 1966, the Meier Cyberbullying Prevention Act. Our next panelist is a gentlelady from the 20th District of Florida, Representative Debbie Wasserman Schultz. She is in her third term and is a member of the Judiciary Committee and the Appropriations Committee, where she serves as chair of the Legislative Branch Subcommittee of the Appropriations Committee. She is the lead sponsor of H.R. 3630, the AWARE Act. And our final panelist, we expected the gentleman from the 7th District of Texas, Representative John Culberson, but he was unavoidably detained, and we'll have his statement entered into the record. Each witness's written statement will be entered in the record in its entirety, so I ask our witnesses to summarize your testimony in 5 minutes or less, and we'll begin with the gentlelady from California.
Thank you, Mr. Chairman and Ranking Member Gomert, for allowing me the opportunity to testify today about this piece of legislation. I'm pleased to be here talking about the critical issue of child online safety because it's a relatively new form for Congress to be grappling with. When I was first elected to Congress, I held a series of meetings with local school superintendents and law enforcement leaders to learn more about the challenges that they face in keeping kids in school and on the right track to becoming productive citizens. And unfortunately, I heard a recurring theme during this series of meetings, and that was that bullying isn't a harmless prank or some kind of rite of passage. It's dangerous both physically and mentally for students. Bullying leads to things like poor school performance, absences from school, or even dropping out of school altogether. The prospect of assault and harassment can lead a child to join a gang for protection. Not only can bullying cause physical injuries in the form of wounds, bruises, and broken bones, but it can also lead to depression and even suicide. That's why I've been working to change federal laws so that schools can use federal funds to address and prevent bullying and harassment. But over the last several years, I've learned that that approach isn't going to be enough, because bullying has gone electronic. It occurs in text messages and GChat, on Facebook and MySpace, on cell phones, and on the internet. This literally means that kids can be bullied any hour of the day or night, and even in their own homes, which is a marked contrast to the bullies of yesterday that could only bully on the playground. Today's kids are so wired into their electronic social networks that they type more messages than they speak each day. Their virtual world is more real to them than the so-called real world is. For those of us over 30, this can be difficult to comprehend, so I want to give you an example to illustrate the problem. Imagine, if you would, in our day when we went to school, a student brought out a jumbo-sized TV into the school quad and played for the entire student body a videotape in which he threatened and harassed a second student. By the end of the day, everyone, and I mean everyone, would have seen or heard about it. Well, that's exactly what cyberbullying is. Because of the anonymity and deception in the internet, this form of bullying is particularly dangerous. If Bobby posts a video, and I don't mean the chairman, on his Facebook page that harasses and threatens to rape and kill Ashley, that video isn't private. It's not buried on Bobby's profile page somewhere. It's public. It appears when any of Bobby's Facebook friends log in, right up there on front of their homepage, so they can't miss it. And this story isn't just hypothetical. It happened to a brave young woman named Hale Ketchum Wiggins, who lives in Southern California near my congressional district. Similar bullying incidences are happening every day to young people across our nation. Cyberbullying is always mean, ill-mannered, and cruel, but some cyberbullying is so harmful that it rises to the level of criminal behavior. My bill, the Meier Cyberbullying Prevention Act, is named to honor a young woman who was a victim of such criminal behavior. 3 years ago, 13-year-old Megan Meier of Missouri hanged herself after being tormented and harassed by her 15-year-old MySpace friend Josh. Josh told her, among other things, the world would be better off without you. Eventually, Megan's family learned that Josh was really a creation of Lori Drew, the parent of one of her classmates. However, local prosecutors in Missouri couldn't bring charges against Lori Drew because at the time, Missouri had no law to punish that kind of cruelty. A federal prosecutor in a similar bind got creative and charged Drew with computer fraud. And even though a jury convicted her, a judge threw out the conviction. The result is that Drew, an adult, and one who should have been setting an example of good behavior, will never be punished for her outrageous behavior towards her 13-year-old victim, Megan. These are just a few brief examples of why Congress needs to address new crimes like cyberbullying. Words that didn't even exist just a couple years ago, including sexting and textual harassment, describe the new ways that people use technology to hurt, harass, and humiliate others. When these behaviors become serious, repeated, and hostile, we can no longer ignore them and turn a blind eye. While Missouri has since enacted a cyberbullying statute, the children of other states are waiting for Congress to act. That is why I'm grateful that the committee is considering the Megan Meier Cyberbullying Prevention Act. Before I conclude, I do want to acknowledge how difficult it is to craft a prohibition on cyberbullying that is consistent with the Constitution. But I believe that working together for the sake of our children, we can and must do so. The Supreme Court has already recognized that some regulation of speech is consistent with the First Amendment. For example, the court has approved restrictions on truth threats, obscenities, and some commercial speech. But it has been more hostile to attempts to limit political speech. I don't intend anything in the Megan Meier Cyberbullying Prevention Act to override Supreme Court jurisprudence. Instead, I want the law to be able to distinguish between an annoying chain mail, a righteously angry political blog post, or a miffed text to an ex-boyfriend, all of which should remain legal. But serious, repeated, and hostile communications made with the intent to harm are different. When the latter rises to a criminal level, as it did in the case of Lori Drew, prosecutors should have a tool at their disposal to allow them to punish the perpetrator. I believe that we can protect our right to free speech and protect victims of cyberbullying at the same time. And I look forward to working with my colleagues on both sides of the aisle to do so. I thank you for the opportunity to testify today and hope that you will join me in supporting that legislation.
Thank you. Ms. Walshman-Schultz.
Thank you.